Let us now look at other IP rights. Let us take the trademark first. Now, what you see on the screen are certain trademarks. What they represent to us? They represent to us footwear. But we know that product of Bata is not same as product of Reebok. Bata is not Reebok. Paragon is not same as Puma. Liberty is not same as Nike. As a customers, we are very clear what product each company sells. There is no confusion in our mind between the product of Bata and product of Reebok or Puma. This is what the trademark does. Trademark is a sign that individualizes the goods of a given enterprise and distinguishing them from the goods of its competitors. Trademark has to have two main characteristics. It has to be distinctive and it should not be deceptive. Let me explain these two terms. When you say distinct, when we say Apple computer, there is no connection between Apple and a computer. The word Apple is completely distinct from computer. But when you use word Apple for the apples, it becomes a descriptive. It describes the nature of the goods or services. Deceptiveness. When that trademark claims the quality for the goods that they do not have. There is an American company called Rice Tech. They are based in the state of Texas. They sell an ordinary kind of rice under the trademark of Texmati. The moment you read Texmati, in your mind Basmati comes. You start feeling that it is a Basmati. That is not the case. So, that is a deceptiveness. So, your trademark should not claim or give an impression about the quality of goods that they do not possess. Now, what constitutes a trademark? Trademark may consist of words, designs, letters, numerals, packaging, slogan, devices, symbols, etc. We will see some examples of that. Then there is a service mark, which is similar to trademark, but it is applied to a service. Indian Post runs a courier service, they call it as a speed post. So, speed post is a service mark. Then you might have seen holograms on many products, they are also trademarks. Sound mark, MGM Studio, Roaring Lion, or even advertisement jingle is a kind of sound mark. Shape of the products. All of us are aware of Toblerone chocolate, a triangular chocolate. The triangular shape has been trademarked for the chocolate. So, nobody can produce triangular chocolate. Latest is scent as a trademark. Now, let us look at examples. Word Apple for computers, Deutsche Bank for a bank, some arbitrary or fanciful designations, say Coca-Cola, Nikon, Sony, Nike, EasyJet. All these words have no dictionary meaning, they are arbitrarily coined words. Then there are names, Ford, Peugeot, Hilton for the hotel. These are family names, like we have Tata, Birla, Goenkas. Then slogans, fly me for an airline. L&T says it is all imagineering. Then devices, the star for Mercedes-Benz, the flying lady for Rolls-Royce. These are all trademarks. You cannot use them for other products. Then the number, the 4711 cologne, 555 cigarettes and so on. Then letters, GM, Fiat, VW, KLM, 3M. Many of these are abbreviated words. GM is a General Motors, VW is Volkswagen, 3M is Minnesota Mining and Manufacturing Company. They are no longer in mining, so they have abbreviated their name to 3M. In India, we have ITC, Indian Tobacco Company. Their main business used to be tobacco. Today it is about 30%. 70% is their agri-food business. So they aggregated their name to ITC. Then pictures are symbols. Lacoste, small crocodile which you see on apparels or footwear. In addition to distinguish product of one manufacturer from another manufacturer, trademark also has a secondary meaning. It creates a kind of mental association among the customers so that they come to expect that a product sold under a particular trademark comes from a unique source and has certain unique qualities or attributes. This association is referred as a secondary meaning and is the basis for creating a trademark, and it generates a market demand and a profitability for the company. What is the period of protection? Trademarks can be indefinitely protected. Unlike a patent which is only for 20 years, you can indefinitely protect your trademark. You will get protection for 10 years at a time, which you can keep on renewing. There are trademarks which are 200-year-old, like DuPont, GE, and so on. Let us now look at another IP right, copyright. It is a right to copy and making use of literary, dramatic, musical, artistic works, cinematographic films, records, broadcasts. It includes databases, computer programs, multimedia products. In India, computer programs, that is software per se, is protected under a copyright. You don't get patents for a computer software per se. If software is embedded in a hardware, then you can get a product. We have separate guidelines for computer implemented inventions. Copyright comes into existence as soon as the work is created. For legal protection, it needs to be fixed on a medium. When we say fixed on a medium, it must be written down or recorded so that it can be produced as a proof or evidence in the court when you litigate. The medium of fixation can be anything. It can be a paper, it can be a palm leaf, it can be a digital medium. It doesn't matter what medium it is, as long as it is recorded. What is covered by copyright? Copyright protects works. That is expression of thought and not the ideas. For example, a plot is not protected. If there is a plot, different writers may build stories which are different, but the plot remains the same. So every expression gets a protection. If you take a group of students on a sea beach in the evening when sun is about to set, and you ask them to draw and paint the scene, sunset over the sea, the scenario is exactly the same, but each student, based on its abilities, imagination, creativity, will draw and paint a different picture. Now, each of those students will get a copyright on what they have created. You get two kinds of rights under the copyright. One is economic rights, to use the work or to authorize others to use the work. You get a right of reproduction, right of performance, right of broadcasting, right of communication, right of translation and adoption. These rights you can assign to somebody, license to somebody for the compensation or a royalty. Therefore, it is an economic right. Second right is you get a moral right, right of authorship. So you can object to the work being distorted or used in a context that is prejudicial to the honor and literary artistic reputation of the author. You can't vulgarize Gulzar's song. When you do that, it affects his reputation. So he can sue you to exercise his moral rights. He may have given away economic rights to a film producer, but he retains the moral rights to object and sue somebody whenever his work gets distorted. Period of protection under the copyright is 60 years after the life of the author. Mahatma Gandhi passed away in 1948. Copyright in his work existed till 2008. Cinematographic films, it is 60 years from the 1st January after the work was made public. In the case of broadcasting, it is 25 years from the date of broadcast. Photographs in applied artwork, it is 25 years. After that, work comes into public domain. Today, anybody can publish Mahatma Gandhi's books without any obligation to the Narjivan Trust who held their rights. Let us look at now design rights. Very often, our purchasing decision is influenced not by the practical efficiency of the device, machine, or item, but by their appearance. There may be two scooters of 50cc each, giving the same mileage, but we like one over the other because of the styling, because of the lamps they have been designed, positioned, because of the color. So, all this is intervention of a design professional. He or she has put in creative efforts to give that appearance. So, the artisan, creator or originator of design which gives that attractive aesthetic look should also be rewarded. Therefore, the design protection is given. Now, what is a design? Design means only the features of shape, configuration, pattern, ornament, or a composition of lines or colors applied to any article, two-dimensional or three-dimensional, by any industrial process, which may be manual, mechanical, or chemical, which in a finished state appeal to the eye and are judged solely by eye. So, purely aesthetic aspects. Period of protection varies from 10 to 25 years depending upon the country. It is subject to timely renewal. You get 10 years at a time. Let us now look at trade secret. A trade secret can be any formula, pattern, idea, process, physical device, or a compilation of information which provides its owner a competitive advantage in the market. A trade secret is expected to be treated in such a way that it is not available to others unless they obtain it by theft or by improper acquisition. Let us take the examples. It may be a recipe, it may be a chemical formula, survey methods, confidential data, computer programs, manufacturing process, marketing strategies, financial strategies, or new inventions for which patent application is yet to be filed. Generally, information will be protected as a trade secret where other forms of IPR cannot be used. For example, when you have an idea, a negative know-how, or you do not wish to put it in public domain, you want to keep it to yourself, then it becomes a trade secret. Very often, startup inventors ask me whether they should keep it trade secret or patent it. See, patent gives you a life of 20 years, plus you have to pay fees. In the case of trade secret, if you have ability to keep it secret for a longer period than 20 years, then you can get a protection for longer period. But you run the risk of somebody reverse engineering it, independently developing it, and then filing for a patent. And if he gets a patent, then he can stop you. Then you lose out. Again, how do you enforce a trade secret? How do you prove that other person is using that information? He has stolen it, improperly acquired it. Very often, process information which is used within the plant. The products remain the same. Now, how do you prove within the factory of someone else what process is used? So, you have to take a call based on these factors. Normally, if it is not easy to reverse engineer, normally it is a kind of process kind of information you like to keep it trade secret. TRIPS, which is an international agreement called Trade Related Intellectual Property Services. According to them, for any information to qualify as a trade secret, the information must be secret, it must have a commercial value, it may be subjected to reasonable step by the holder of the information to keep it secret. What are those steps? Limited number of people who have access and are aware that it is confidential. You need to sign confidential agreement with business partners whenever disclosing confidential information. Confidential agreement with all your employees. You need to put certain physical restrictions. Access to that area where confidential work is done, access where that confidential documents are kept, repositories, all the actions which we can take to maintain security in a digital area, because today most of our records are in digital format. Trade secrets are usually managed by a non-competition agreement, so that people not only will not disclose, but also not compete with you based on that information. They may be their employees who leave, join the competition, or the vendor who is working for you. So, you need to have a comprehensive IP strategy. That IP strategy should support long-term product development goals, not just ad hoc innovation. Very often, we do development work, come up with some interesting results, and then we decide to file a patent. IP landscape should be seen first, gaps should be identified, and a roadmap needs to be built. An IP strategy should look at how we are going to fill those gaps, what new things we are going to develop which are patentable. We must focus on inventive steps, competitive advantage of our product, look at patentability requirement, and whether that has a freedom to operate. Again, remember, IP strategy is always directed at the competitor and competitors' products. Value of any given patent is not obsolete. The value of patent is always related to the competitor's patent filing. What does their patents contain? What is their scope? What features they cover and what you are going to cover? In order to have a stronger protection, you must have multiple rights: patent, trademark, domain names, design rights, and also in different geographies. Very often, startups make certain common mistakes. Failure to look at prior art. They don't look at what already exists, what is already published, what is already patented, what products are in the market. And then later on they discover that somebody else has a patent. They cannot bring the product to market, they can't get a protection, and they can get sued by the competitor. Very often we mix up pre-existing IP. We hire employees from some other companies or other startup working in the same area. They bring in certain body of knowledge, and we have certain knowledge. Now they get mixed up, create confusion and litigation. Our employment agreements do not have confidentiality clause. Service agreements do not have confidentiality clause. They do not have obligation to assign patents to the organization. Sometimes there are assignments which are with restrictions. Timely filing is not done. Under the law, there are requirements of timely filing. Once you file an application, you have to put up an application for examination of that application. You file an PCT application, after it is published, within 12 months you have to file. So those actions are not taken. Very often untimely disclosures are done. Before application is filed, you make a presentations on a public platforms. You exhibit your products. You don't think if your validity of the patent is challenged, how you will handle it. You don't look whether you have freedom to operate. Sometimes you license out exclusively your patent to somebody in a critical field, and then you are yourself not able to practice that invention. And in the end, startups, because they have limited money, they decide to handle patenting or other IP rights themselves. Do it yourself philosophy. I always advise not to do it yourself, because you have no in-house resources to deal with IP rights properly. You can even define or identify what rights your invention should get. Should you apply for a copyright? Should you apply for a patent? Should you apply for a design right? The large number of national and international regulations which you are not aware. You do not have a knowledge about common procedures, court judgments, because ultimately patents are litigated in the court. You do not know how courts interpret the claims. Professionals who are in the business of patent drafting, litigation, they will draft your claim keeping all those in mind. And you have no resources to proactively protect your IP. Therefore, don't do it yourself, go to professionals. In conclusion, there are certain takeaways. IP is a valuable asset, and IP management is a key for success in high technology ventures. If you don't do it, somebody else will. If you are not protected enough, competitors will take advantage. Then your ability to monetize your intellectual property will disappear. And when that ability is not there, investor will have no interest to invest. You will not be able to scale up and make a successful business. Thank you.